Hello, everyone, and thank you for joining us for this recorded webinar, where we will be talking all about cyber failures, which has been a very hot topic in the news recently. My name's Ed Kilner, and I'm a senior commercial solicitor at Harper James, and I'm joined by my colleague Becky White, a senior solicitor from our data protection team.
Thanks, Ed. Hi, I'm Becky. I thought it would be firstly useful to put some structure around this and walk you through what we're going to cover today. So first of all, Ed will start by looking at what a cyber failure is. Then he'll take you through how you can prepare for a cyber failure in advance, and then on to how you can deal with one happening. After that, it's over to me, and I'll talk you through what to do if the cyber failure is classified as a personal data breach, which has specific ramifications under data protection law, which is my area. Ed will then sum up what we've been talking about. So it's worth noting that some of what we will be talking about will be legal and some of it will be more commercial and practical advice. So without further ado, over to you, Ed.
Thank you, Becky. So first of all, we're going to give you some context and explain what we mean by a cyber failure, as this is obviously a very broad term. But when we talk about a cyber failure, we can mean some kind of data breach, which itself is quite a broad term, could mean hackers have stolen data or are preventing access to it, or we could mean some kind of technical outage, meaning a system is unusable or inaccessible, which could be caused by some kind of ransomware or DDoS attack. And I think it's also worth covering the kinds of risks and liabilities that can arise from a cyber failure. So thinking about things from a legal perspective, you could have claims from customers for breach of contracts if the service you're providing isn't available to them. If there has been a data breach, customers could also look at claiming damages for loss they have suffered as a result of confidential business information being disclosed to unauthorized third parties. If personal data is involved, there might also be potential fines from a regulator and claims from affected data subjects, as well as additional claims from your customers if they are in turn being investigated by the regulator or are themselves being pursued by data subjects. There's a lot of different angles from which a claim can be made against you here. And on top of that, from a more practical and commercial perspective, the reputational damage could have a longer effect if it affects the confidence of your existing or prospective customers. And there's also the employee and management time lost spent dealing with the fallout, and your insurance premiums will likely go up as well. And there's a lot of examples of cyber failures hitting the news now too. We've had the AWS outage in October 2025 that caused thousands of platforms to go down, in the likes of Snapchat, Reddit, banks like Lloyds, and even online computer game Fortnite. This is a great example, as it wasn't even a cyber attack and was actually caused by an internal configuration error. We've also had a Jaguar Land Rover, which has had a huge economic impact in the West Midlands, estimated to be the most economically damaging cyber event in the UK's history, costing £1.9 billion. And this was a cyber attack caused by stolen credentials, stolen using voice impersonation techniques, leading to a ransomware attack. This resulted in JLR's factories being shut down for 5 weeks and having a huge knock-on effect for their suppliers and their customers. Embarrassingly for JLR, it has also transpired that they did not have cyber insurance in place, the importance of which we will emphasize again later on. Then there was the M&S data breach, again a huge cyber hack involving system disabling ransomware and stolen data. M&S couldn't trade online while their systems were down and lost £300 million in revenue. And there could be third-party claims including data subjects and regulatory fines as well. An interesting contrast to JLR, they did have insurance in place and have apparently received £100 million from their insurers so far. Now, obviously these are examples of cyber incidents experienced by huge businesses and are at the very extreme end of the scale in terms of some of the numbers we're talking about. But it can happen to anyone, and we have seen it affect businesses of all sizes. And as we saw with AWS, even these incidents affecting huge multinationals can have a knock-on effect for anyone using their infrastructure. Unfortunately, the reality these days is that it's probably inevitable that you will experience some kind of incident, whether it turns out to be severe or not at some point. But with that cheerful inevitability in our minds, we're going to talk about some steps you can take to mitigate your risk. First of all, put a disaster recovery and business continuity plan together. Now, I know this probably sits somewhere near the bottom of the to-do list for lots of SMEs, but you do need to find the time for this because it's going to be your first port of call when you're in panic mode after a serious incident happens. So it pays to do the thinking on this in advance when you've got more time and clarity of thought. It doesn't have to be long. Even a one-pager is better than nothing. if it outlines who you need on your team in that moment, what your decision-making hierarchy looks like, and what initial steps you should take towards risk assessment and containment. This will help guide your thoughts and initial actions when an incident happens. Beyond this, though, more broadly, you need to analyze and document all of the potential risks to the business and what their effects might be. Once you've identified the risks, you can develop a strategy to mitigate and combat them. Can you build more redundancy into your infrastructure? Can you fail over to a backup system? How confident are you in your data backup processes? Do you have relationships in place with third-party cybersecurity professionals that you can call on if you need more assistance? And these are technical and operational questions, not legal ones, but they are the questions that you need to be asking now in order to give yourself the best chance of surviving a crisis. Secondly, insurance is essential, and the differing experiences of JLR and M&S testify to this. A lot of you are probably using any one of the big cloud providers like AWS. And as most of their customers will have found out after their outage, AWS don't offer high liability caps, normally about 12 months worth of fees. And that means bringing a claim is not really viable and insurance becomes critical. And I don't just mean professional indemnity insurance, but cyber insurance too. As we discussed earlier, losses and claims can come from multiple angles. You might incur costs in dealing with and fixing the issue, but also get a fine from the regulator, or even a claim from a customer or data subject if you're really unlucky. You need to check if your insurance policies cover all of these types of losses. Sometimes this can be split between your professional indemnity coverage and a separate cyber insurance policy. You should also check whether the coverage limits are aligned with the liability caps in your customer contracts. And a good insurer will also act as a partner who can help you identify vulnerabilities before a serious incident happens. They obviously have a lot of experience dealing with the fallout from these things, so use their expertise and let them do their due diligence on your infrastructure. Next is my favorite bit, review your contracts. Firstly, on the supplier side, what liability caps have you accepted from your other suppliers outside of those like AWS? This will dictate your potential recovery if they cause you a problem. And in each of the cases of JLR and M&S, it was a third-party supplier where the issue arose. In my experience, security incidents and data protection are areas where you can generally push for higher liability caps. Suppliers expect it because they know the risks, and they know it's market standard to offer higher caps, even unlimited liability if you can get it, and they want to stay competitive. This also means your suppliers will be more aware of their own exposure if they get something wrong as well. But liability caps are only one piece of the jigsaw here. There are plenty of other contractual protections that suppliers can offer that can mean you can be more comfortable accepting a slightly lower liability cap. Obviously, AWS trade off their track record and being best in class for reliability generally. But for other suppliers, you could be asking about things like service levels, ensuring quick resolution times are provided and not just response times, which could just be an automated acknowledgement email. Do they offer service credits, and are they the sole and exclusive remedy for downtime? If so, you will struggle to bring a claim for other losses. Also, what are their other obligations in the event of a breach? Do they commit to carrying out a root cause analysis, keeping you updated on an ongoing basis, maybe giving you a specific contact you can get in touch with, and committing to remediating the issue as soon as possible? Do they offer indemnities? Again, the detail is key here. Does it just cover breaches of the data processing agreement, or does it cover all losses arising from the data and security breaches generally? And is this indemnity subject to a cap? Finally, most suppliers now will offer some kind of security schedule where they commit to implementing certain security measures, and you should ask to see your suppliers. If they don't have one they can provide, that is in itself a bit of a red flag if they're going to be providing services that sit within your tech stack. If they do provide a schedule, give it to someone in your security team to review to assess its credibility. On the customer contract side, you are generally looking at the same issues from the opposite perspective. So check both your standard customer terms and contracts you have negotiated. You ideally need to be keeping a log of deviations from your standard. Check your liability caps to assess your exposure if you receive a claim. I always try and make sure clients are agreeing liability caps with customers that are within the liability caps they have been offered by suppliers. This prevents you being stuck in a liability gap where a third-party supplier causes an issue that affects your customers, and those customers can claim back more from you than you can from the errant supplier. Similarly, what have you committed to in terms of your responses in the event of an incident? Have you committed to specific timeframes for notifying customers? And do they align with the timelines you have agreed with suppliers? Ultimately, you will probably never achieve the perfect position in lining up your customer and supplier contracts, especially as an SME reliant on huge global providers. But if a serious incident occurs and you're at risk of receiving a claim, you will be grateful for having pushed negotiations that little bit further to see how much you can close that gap. Now let's talk about the aftermath of a security incident. If it's a serious incident, the first 24 to 48-hour window will be full of stress and firefighting. But businesses that respond well in this window tend to emerge from crises relatively unscathed, whereas businesses that fumble these first 48 hours often find themselves dealing with the consequences for months or even years afterwards. So we're just going to give you a little bit of a framework to think about your response in this time period. First of all, refer to your business continuity and disaster recovery plan that we referred to earlier. Gather your team immediately and only get the people involved who need to be involved, because anyone else could slow you down. And you need to be patient at this point. Don't rush into anything, because you can easily make things worse at this stage. Follow the plan that you have already outlined. Secondly, your first priority is ensuring security before operational recovery. You need to assess whether there's any risk in getting your systems back online. There have been a number of cases where businesses have prioritized operational recovery because they're so focused on the loss of revenue, and they have restored their systems without properly fixing the issue that caused the outage in the first place. Bear in mind this could take some time. Think of M&S and JLR, but in each case, the risk of prioritizing operational recovery was far greater than resolving the underlying problem. Thirdly, you need to be forming a plan for your communications to customers and other affected parties from an early stage. Becky's going to talk about your regulatory obligations to report data breaches shortly, but if the incident affects a service you provide to your customers, you're likely to have a general contractual obligation to notify them about the issue anyway. Your customers might not be able to use your service, for example, if you provide payroll services and they need to pay their staff, or equally as serious, the issue might be preventing them from providing their service to their own customers. And AWS is obviously an extreme example of this. And this will probably be one of the more stressful steps that you have to take, because nobody wants to go to their customers and say, we've had a problem and we're still figuring it out. But it's always best they hear from you as early as possible. And it doesn't matter if you don't have all of the answers yet, because a proactive approach gives them confidence that you're on top of the situation. You also need to make sure that you keep a record of what happened in every decision you make. This kind of documentation can be crucial if the regulator wants to investigate and as evidence of the steps you took if there is ever a claim made. Finally, you do need to think about your regulatory obligations from a data protection perspective as soon as an issue arises. So I'm now going to hand over to Becky for the next section.
Thanks, Ed. So, first of all, before we look at responding to a personal data breach, I thought it might be helpful to just consider what personal data is in this context. Well, it's actually any information that relates to an identified or identifiable individual. So we're talking about individuals here, so individual customers, not business customers necessarily. And this includes obvious examples like a name, a photo, and an email address, and also less obvious examples such as an IP address or location data. So, following on from this, the obvious question to ask is, what is a personal data breach? Well, there is a specific definition in UK GDPR, and that is that a personal data breach is, and I'm going to quote the law here, a security incident that results in the accidental or unlawful destruction, loss, alteration, unauthorized disclosure of, or access to personal data. And if this situation arises, there are several specific legal obligations that are triggered under data protection law. It's worth noting that this legal definition potentially covers a wide range of incidents, including, but not limited to, a cyber failure or incident, the kind that we've just talked about. But it also includes everyday errors like accidentally sending an email to the wrong person, or uploading a document online with unredacted personal data. And in fact, those are two of the most common types of personal data breaches. So, as already mentioned, not all cyber failures are necessarily a personal data breach. It really depends on what happened and what information has been compromised, in particular, whether personal data has been compromised. Handling personal data breaches correctly is important for any business that deals in personal data, whether that's email addresses, payment details, health information, or staff records. For one thing, there's the potential reputational damage, which can be catastrophic, but also the Information Commissioner's Office, known as the ICO, but soon to be rebranded as the IC, can take enforcement action against organisations who get this wrong, including levying potentially eye-watering fines, which nobody wants to be receiving. So, the first thing that you need to determine if a personal data breach situation arises is whether you are a data controller or a data processor of the compromised information, as both have different roles and responsibilities in the event of a data breach. Hopefully, this is something you would be aware of already and you wouldn't be working it out as the situation arises. But if you don't know that already, you do need to quickly work that out so you can understand what you need to do. So, to summarize the difference, a controller decides why and how personal data is used, whereas a processor carries out the processing on behalf of the controller. The processor is following instructions, so not setting the agenda. For example, if you are an employer using a third-party payroll company, you are the controller and the payroll company is the processor. Or to use an example that we've already touched on, if your company is using Amazon Web Services, AWS, for cloud storage solutions, AWS is a processor acting upon your instructions to store personal data. So, a data controller's role is enshrined in UK GDPR, and it has the primary responsibility for assessing the severity of a personal data breach and deciding whether the breach is reportable to the ICO and whether data subjects, i.e., the individuals themselves, should be notified. The test to apply when a controller is determining whether an incident should be notified to the ICO is whether the breach is likely to result in a risk to the rights and freedoms of individuals. Now, this is quite a difficult test to apply, and although there is some guidance on the ICO website about how to make this determination, it really is quite a grey area in some situations. Of course, we can assist you with making this assessment if you're unsure and you want the confidence of having sense check this against somebody else before you make that notification or not. However, all of this does need to happen within 72 hours of the controller becoming aware of the breach, i.e., finding out about the breach. And if the assessment demonstrates that the severity threshold, i.e., that test that I just referred to, is met, then the ICO must be notified within this framework time of 72 hours, which is 3 days. Now, I know 72 hours does sound like a long time, but trust me, it goes by really quickly when you're in the middle of a crisis. And it's not 72 business hours, it's 72 actual hours. So if you discover the breach on a Friday afternoon, the clock starts ticking then. And by Monday, you must have gathered all the facts, assessed the scope, determined who's affected, and if necessary, prepared your notification to the ICO. All of this takes time, and the clock doesn't stop ticking because you've run over the weekend. This is why this assessment of whether that test is met needs to happen immediately, in parallel with the operational response that Ed just went through. Unfortunately, you don't have the luxury of getting your systems back up first and thinking about data protection. On top of this, the controller is also responsible for determining whether the data subjects, i.e., the affected individuals, need to be notified, the individuals whose personal data has been compromised. And the test there is slightly different to the test for ICO notification. Essentially, if the breach is likely to result in a high risk to individuals, then you need to think about notifying those individuals directly. So that's more than just a moderate impact, it's a high risk. And you need to think about what you're saying to those individuals and giving them the opportunity to take steps to change passwords and protect their information as soon as they can. In both cases, whether you're notifying the ICO or notifying individuals, you need to document everything. Even if you decide not to notify in either case, you need to be able to demonstrate and justify why if you're ever challenged on this. Keep a record of what facts you considered and how you reached that decision. As already mentioned, a processor carries out processing on behalf of the controller. Often, a personal data breach will actually happen on a processor's watch and not have much to do with the controller's actual handling of the data at all. The processor's obligations when a personal data breach occurs are largely driven by the contract between the controller and the processor. So you need to have that contract handy and understand your obligations in the event of a data breach. UK GDPR sets out specific requirements that this contract, often known as a data processing agreement or a DPA, which will form part of your overall main commercial contract, must contain. Some of which will cover how the processor needs to react when a data breach occurs. This includes issues such as the time frame within which the processor must notify the controller after becoming aware of a data breach, or what information needs to be communicated in the event of a data breach. Also, the obligation for the processor to assist the controller in assessing and investigating the breach, as well as preparing ICO notifications and notifications to individuals if necessary. And quite importantly, it may also cover an agreement as to the allocation of liability where the personal data breach arises from the process of failures. This is commercially very important, as we've touched on previously, such as the AWS example. So, if you are the processor in this scenario, make sure you look at your contract, as you don't want to be looking at a claim for breach of contract as well as potential enforcement from action from the ICO. Look at your contract to make sure you understand what you're contractually obliged to do if a data breach arises. Many businesses assume that processors can't be fined by the ICO, but that is not true. The ICO has made it clear that processors can also be fined directly. So what can you do in advance to mitigate the fallout of a personal data breach? One of the most important things you can do is train your people. Train them on data protection generally, but also train them on what to do if a personal data breach arises. Training should be role specific. For example, if you're training somebody in finance, show them how phishing attacks target payment details. Or if you're training someone in HR, teach them how to ensure sensitive information that might be on HR systems is adequately protected. And training shouldn't just be an induction, it should be refreshed and embedded into your culture. Also, plan your breach response, like Ed set out previously for the commercial and operational response. As stated earlier, a controller only has 72 hours to notify the ICO, and often you don't even know the full scope of the breach within that window. So you need a response plan ready to go. This includes designating a response team and establishing a triage framework. And very importantly, make sure your business has implemented appropriate technical and security measures to protect all your information.
Thanks, Becky. And I think that highlights that a lot of this is really practical stuff you can do, as much as there are legal mitigations that we can help you with. And we're going to go through a quick summary in the form of 2 checklists for steps you can take. One for preventative steps you can take right now, and one for the first 48 hours after an incident occurs. For steps you can take right now, as the first step, make sure you have updated that disaster recovery and business continuity plan. As I said earlier, this doesn't have to be war and peace. At least outline the team you need and your decision-making hierarchy. Second step, aim to carry out a practical risk assessment and develop a strategy to mitigate the risks you identify. Thirdly, review your insurance coverage. JLR didn't have it and it's really cost them. But don't just check whether you have it and leave it there. Check whether it's adequate for your actual exposure. and ensure you have PI and cyber coverage if that's what you need, and check this with your broker. Finally, audit your contracts, because you need to understand what liability caps and obligations you are agreeing to in your customer contracts, particularly the heavily negotiated ones, and your supplier contracts. If there is a gap, you need to be aware of this and address it. Moving on to your crisis response checklist. Firstly, refer to that disaster recovery plan and assemble your team immediately. Secondly, be patient and prioritize ensuring security before operational recovery. Third, form your communications plan. Your customers may already be aware of the issue and will expect transparency from you. You don't need to have all the answers just yet. Tell them what you know, what you're doing, and when you'll update them again. Fourth, document everything straight away, everything that happens and every decision you make, because this could be your savior further down the line. And finally, assess the data protection impact immediately. This is, of course, Becky's domain, but right from the start, someone needs to be assessing whether personal data has been compromised and what your notification obligations are. This could be to data subjects, customers, the regulator, or even all three. And so that's the end of our 2 checklists. We've covered a lot of ground today. What a cyber failure might look like and the risks to your business, what you can do to prepare for one, and how you can deal with the aftermath of one. And we're going to finish by quickly outlining a few ways we can help you implement what we've talked about today. Firstly, business continuity planning. We can work with you to create a practical, actionable business continuity and disaster recovery plan. This isn't about creating a massive document that sits on a shelf. It's about creating something you can easily use when a cyber failure occurs. This is a framework that your team can rally around in a crisis. Secondly, supplier and customer contract reviews. We can carry out an audit of your key contracts, both supplier contracts and customer contracts, to identify where your exposure is, whether you have any gaps between your liability caps and supplier and customer obligations. And obviously, we love negotiating contracts too. That's the really fun bit for us, and where we can really help you mitigate those risks as you take on new suppliers and customers.
With regards to the data protection aspect, if you do suffer a personal data breach, we can help you assess the incident in that all-important initial 72 hours to confidently decide whether it's notifiable to the ICO and data subjects or not. We can also help you manage the ICO notification process and communicate with affected data subjects if necessary, and support you with the remediation process. Don't forget that, breach aside, we can also work with you proactively before a breach even happens and help you to get your data protection house in order ahead of any incident occurring, so that you're in a strong position to react quickly and compliantly. And finally, please do subscribe for our follow-up resources. We regularly publish articles and guides on these topics and many others. You will find these on the Knowledge Hub on our website. We also run regular webinars like this one, where we try and give you a more in-depth, practical guidance, and we keep a library of these webinars, so make sure you're subscribed to our marketing emails to receive all of this content as we release it. Right, I think we're just about at the end of our time slot. Thank you so much for joining us today. I hope you found this webinar helpful, but if you've got any questions, please do get in touch.